Hi, thanks for joining me today. Today I'm going to talk to you about mediation, which is something that comes up often in the litigation context, sometimes in pre-litigation cases, but often when there's a lawsuit. Essentially, mediation is a settlement conference. It's an attempt to get the case resolved outside of trial with the help of a neutral third party who is the mediator. So the way this works is that all of the involved attorneys jointly agree on who the mediator is going to be. This is a person who has a number of years of legal experience. Sometimes they are former judges. And in all cases, they have worked on both sides to help deal with easygoing attorneys, to deal with more difficult attorneys, to deal with insurance adjusters and plaintiffs, all different types of people who are involved in a case. So the important things for you to know about mediation is that the mediator does not make any final decisions. The mediator can only make recommendations. This is how mediation is different from arbitration. Very briefly, arbitration is kind of like a baby trial, where the arbitrators act as judges who say, your side wins, your side loses, this is how much money. Mediation doesn't work that way. Mediation is really just a discussion with the mediator to help facilitate that back and forth between the parties. So beforehand, the attorneys for each side will send materials to the mediator explaining a little bit about their case. They'll talk about why we're here, if it's a car accident, a slip and fall, whatever the incident was that brought about the lawsuit, who the parties are, and in a personal injury context, information about the injuries. So that includes medical records, it includes an explanation of the treatment that the plaintiff has had, and also some information about the kind of day-to-day general impact that the injuries have had on that person. The defense, on the flip side, sends medical records that they think are important to their case, witnesses that are supportive of their defense, same kind of thing that the plaintiff does, just things that support their side. And so the mediator comes in with kind of a general understanding of the case for both sides, and then they help us with that conversation in the back and forth with sending the numbers to each other, hoping that when we start really far apart, that the mediator can help work us down to a middle ground where everybody's happy and so that we can get the case resolved. And the benefit of that is that it's much faster and cheaper than going to a jury trial, and it puts the power of resolving the case in the hands of the plaintiff. They get to make the decision rather than leaving the case up to chance with 6 random jurors who could make any number of decisions in a trial. Mediation is not always appropriate for your case. There are pros and cons of opting into that process, but that is something that a qualified injury attorney can help you with, and something that I would be happy to talk to you about if you have any questions. Have a good day.